Hi, I'm Tim Moss. I'm the Chief Executive Officer and Comptroller General at the UK Intellectual Property Office, and talking to you on IP Fridays.
Hello and welcome to this episode of IP Fridays. Our names are Ken Suzanne and Rolf Claessen, and this is the podcast dedicated to intellectual property. It does not matter where you are from, in-house or private practice, novice or expert. We will help you stay up to date with current topics in the fields of trademarks, patents, design and copyright, discover useful tools, and much more.
Welcome to episode 109 of IP Fridays. Today's interview guest is Tim Moss, who is heading the UK Intellectual Property Office. Today is Brexit Day, and of course we will talk about Brexit. But before we jump into the interview, I want to tell you a little bit about other things that happened in the IP world. The EU and the UK have now both ratified the withdrawal agreement, the deal. That means that EU law will continue to operate as it does now in the UK until the end of the transitional period of 31st of December 2020. Therefore, EU trademarks and EU designs will continue to have effect in the UK until then. That's good news for all IP holders for EU rights, like EU trademarks and EU designs. Also, the EPO, the European Patent Office, and the UK IPO, they have both rendered decisions for patent applications where artificial intelligence was named as the inventor. All these applications have been rejected, and in my take, it boils down to the fact that both offices decided that artificial intelligences cannot be holder of rights, so the right to the invention cannot be transferred to the applicant from these machines, and therefore the inventor named was invalid. The interview with Tim Moss was recorded, of course, before this day, before Brexit Day. So at the date of the interview, we both did not know that the withdrawal agreement was actually ratified by both sides. Just keep that in mind. Thank you very much and enjoy the interview. I'm very excited to be joined by Tim Moss today. If you don't know Tim Moss, he is the Chief Executive Officer and the Comptroller General of the UK's Intellectual Property Office, and he has taken up this post from 1st of May 2017. Before that, he was at the Companies House, where he was the Registrar of the Companies for England and Wales and Chief Executive since 2012. And before that, his career included 12 years in senior operational roles in the manufacturing industry. He holds degrees from the Cambridge University, an MBA from Swansea University, and I'm very excited to have you on the show. Thank you very much for being here.
Well, thank you very much for having me, and I'm delighted to be here.
So can you briefly talk about what you are doing at the moment? Of course, people might have an idea, but maybe I didn't go into that much detail. So maybe you can briefly describe what you're doing, what your current role is.
Yes, well, as Chief Executive of the UK IPO, I'm responsible for all aspects of this wonderful organisation. We're about £100 million turnover organisation with over 1,250 staff, looking after all aspects of IP for the UK. We cover patents, trademarks, designs, copyright. We do the rights granting, but we also do all the work around policy, legislation, as well as some work looking at how we support businesses, raising awareness and education programs, and also coordinating a lot of protection and enforcement aspects for the UK.
All right. So the UK is in exciting times at the moment. What do you feel is the IPO's role in the world of IP, and specifically in the UK and internationally, and how do you see the organization evolving to be fit for the future?
Well, the first thing I would say, and one thing I've learned over the last couple of years being involved in the exciting world of IP, is that sometimes we get too focused on thinking about IP And actually, what we need to remember is we're actually all about how do we help create the right environment for innovation and creativity. That's the purpose of IP. And so very much the role of the UK IPO links to the government's strategic agenda here, which is how do we make the UK one of the most innovative and creative countries in the world? And our role is to say, what does IP, how can IP contribute to that? And I think it's a really exciting agenda, and for not only within the country but also globally. And the work that we do internationally really supports that, and saying how do we really just increase this whole environment around innovation and creativity.
All right, exciting, of course. But one thing is on a lot of people's mind at the moment, Brexit. Probably you can't hear that word anymore. But I have to ask you, maybe first we talk about some general concepts for what happens to EU trademarks and EU designs. How will the protection of these rights will be ensured in the UK after the Brexit? How does that work?
Well, you're absolutely right. Brexit is one of the number one things. It is the number one thing on our agenda at the moment. And I think the reason it's number one is because absolute priority is ensuring that people's intellectual property rights are maintained throughout this transition. The UK currently has a great IP regime. That's part of the European system, and it will continue to have a great IP regime post-Brexit. But what is absolute of paramount priority for us is to ensure continuity of rights. So for EU trademarks and EU designs, they currently cover the UK, but after the 31st of December 2020, they will no longer cover the UK. And so we must ensure continuity around that. So the work that we've been doing here at the UK IPO has been to ensure that we then create new UK rights to mirror the European rights. So that it will be absolute certainty for all rights holders and continuity of rights throughout this whole transition. And that is our biggest priority.
Mm. And at the moment, it's not really clear whether we have a Brexit with a deal or without a deal. So it could happen that it's not likely, but possible that there would be a Brexit on 31st of January, or basically the Brexit might happen, but maybe there would be no deal. So what is the level of preparedness at the UK IPO for the introduction of the new rights created on the Brexit date?
Yes, certainly. I mean, we've been dealing with all the issues around no deal throughout the whole of 2019. And originally we had to prepare for a potential no deal on the 29th of March last year, the 12th of April, but also 31st of October. And on each of those occasions, we had set up both the legal requirements and the operational requirements to ensure continuity of rights. So we were confident that if we had to leave with no deal on those dates, we would have ensured both legally and in practical terms that all rights would have been secured. Now, as things stand at the moment, the situation is looking as though the withdrawal agreement will be agreed both in the UK Parliament and in the EU Parliament. And so that will come into effect on the 31st of January. And this will mean that actually all things will stay the same right the way through until the 31st of December 2020. So we are prepared and have been prepared for any sort of no deal situation. But the real focus now is on saying how do we plan for events that will happen on the 31st of December, and we have more certainty around that. We are prepared to create what will in fact be, I think, nearly 2.1 or 2.2 million new rights between trademarks and designs on that date. There's some detail that is yet to be worked out, which could be part of the future agreement that happens between the UK and the EU. But I certainly want all your listeners to be clear that there will be continuity of rights and there will be no loss of rights at that point on the 31st of December.
Yeah, people are very relieved by your very uncomplicated solution. I was very happy when I first read about your proposed solution to the EU rights, and many people are probably very happy that it is quite uncomplicated.
The principle we've tried to ensure is that we can give maximum certainty for rights holders and minimum disruption. So we also want to be clear that we will create those new rights automatically on the 31st December, and it will be at no cost to any rights holders. So that process will go smoothly. And even to make it simpler, rather than create a new number for each new UK right, what we've done is we will add a prefix to the existing European number. So essentially the number for the new right will have UK, and I think it's 009 goes in front of the European number. So it's very easy for people to have the identifier for their right when it becomes a UK right.
Yeah, very, very nice. I'm very grateful, and many people are very grateful that you found such a very brilliant solution. So how will the UK IPO be communicating the changes in the procedures as they relate to the Brexit to the public? And is there a place that people can go if they have questions that are not easily answered from the website?
Yes, I mean we did a lot of communication throughout last year, trying to provide sufficient technical detail around what was happening, and all that was available through the gov.uk website. And there is general communications that look at what we're having for the full range of IP rights. The biggest changes do affect trademarks and designs, but there are also some technical issues around copyright and also one or two areas around patents. So we've already done a lot of communication, and now we'll be looking at what more we need to do building up to the 31st of December. And coordinating that, in a sort of cross-government way, because it's important to understand, that the customer or the audience for this, and there'll be an awful lot of messages that need to come out to them, of which IP will be one of them. But we will continue to ensure that there are good communications. And if any of your listeners want to know, that the first place they should go to would be the gov.uk website, and look at the issues around intellectual property.
Yes, actually, I am there a lot of times, and I actually subscribed also to your newsletter. You have an automatic email alert system in place, so people can leave their email with the UK IPO, and then they will receive an email whenever there's an update. So that's really helpful. Thank you so much.
Yeah, and we will continue to increase the communications throughout the year, and whether it be through channels like this with podcasts, but also working with key partners, whether they be the intellectual property profession, or business groups, etc., to ensure that the message gets out to as many people as possible, to ensure that they get the core messages around the certainty of rights and the changes that will be happening.
Then there is another question. There is a withdrawal agreement bill. What is the withdrawal agreement bill, and what does it mean for IP right holders?
I mean, the withdrawal agreement essentially puts into law the agreement between the UK government and the EU, and it covers a complete range of things that the government needs to cover. And as far as IP is concerned, it looks at the different rights and what happens through the point where we leave. So, because we actually are leaving the EU on the 31st of January, and then we enter an implementation period. And the withdrawal agreement sets out what happens during that implementation period, which essentially, from an IP perspective, is nothing changes. And everything carries on as it was throughout the implementation period up until the 31st of December 2020. It then looks at what will happen to existing rights as we go beyond there, and this sets the legal framework for the sort of continuity of rights that we have.
Yes, okay, I understand. So this is basically the counterpart to the EU treaty or proposal, right, that needs to be implemented within the UK. I understand. Yes,
so it sets the legal framework for the position as we leave, right, and go into the implementation period, and then there is some indications about the future relationship. But obviously, that is the thing that is going to be negotiated over the next 11 months to define fully the relationship from the 1st of January next year.
Yes. I am personally prosecuting a lot of EU trademarks and designs, and so I have some really practical questions. So what happens to the pending cases that involve EU trademarks or designs, or litigation cases based on EU rights or revocation actions against EU rights? Let's use a concrete example. Someone has opposed a EUTM, so a EU trademark, just before Brexit Day, and the decision on this opposition will not become final before any of the transition periods, for example, 31st of December. So what happens to the automatically generated UK right if the opposition is successful? And will the decision of the EU IPO be binding for the UK rights as well? So will that also be deleted if the EU TM is deleted? Or does the opponent has to attack the UK trademark separately? What happens to these kinds of cases?
Well, I think that the first thing, when a mark is being opposed, or being, it's treated as though it hasn't actually been fully registered or it's not registered yet. And so in that scenario, there would be no UK right created, because it would still, and the provisions that are built into the agreement around pending applications would come into effect. For pending applications, people would need to file with the UK, but we would then separately with the UK, but we would respect the priority date that exists with the EU application, and the UK IPO will respect any decision of the EU IPO created for any of those any rights going forward. So if the right, if it was the opposition was upheld or rejected, then we would accept the decision of the EU IPO on that.
So we talked about trademarks and designs, but we didn't talk about patents. So what happens in the field of patents? Many say that nothing really changes. However, some small things change, right? So can you talk about that, maybe?
Yeah, I mean, I think for the vast majority of things, from patents, things don't change because, the UK is leaving the EU. It's not leaving the European Patent Convention. And we're still absolutely a core member of that, and will continue to be so going forward. It's hugely important to the UK and to businesses both in the UK and internationally that we're part of that. And certainly any future deal with the EU and also with other countries needs to be consistent with the UK's membership of the European Patent Convention. So that covers a huge amount of things to do with patents. So on that basis, many things do not change. There are some specifics, I think, around supplementary protection certificates, SPCs, where there is separate EU legislation. And again, we've done provisions to ensure continuity of around that. And also, there has more recently been the EU, regulation directive around manufacturing waiver. Linked to SPCs, and again, that's something that's come into force before the UK has left the EU. So the UK will implement that as well going forward. So there are some bits, especially around SPCs, where there is EU law that will be reflected in the UK, but the vast majority of things for patents won't change.
Yes. So I have one last question. The EU practitioners like myself that are representing EU designs and trademarks, they seem to be automatically entered as representatives for the respective UK rights. So will they be able to fully act on behalf of the clients before the UK IPO, even in hearings? And do you recommend this, or will there be changes to this over the coming years? What do you expect?
I think the position is clear as we leave the EU that we will respect the sort of rights of representation and will maintain those. So that if people are the representatives of the EU IPO, that will move across to the UK IPO for the new rights. And that is part of the principle that I set out earlier of having maximum certainty and minimum disruption for business. And there are some details of this within the withdrawal agreement about how that will be maintained for a period of time. Obviously looking at longer term, that is something that there may well be options for us to look at. and it's something that we'll carefully consider going forward. But I think the first thing is, in terms of the point of when we leave, and that things change at the 31st of December, we will respect the rights representation that currently exist. But that could change going forward. But as I said, the details are put in the withdrawal agreement, and there are options as the UK defines things for the future.
Yes, the UK proceedings before the UK IPO would probably or obviously be governed by UK law, trademark and design law. So, and I'm not familiar with this law, I'm not really comfortable representing clients under this legislation. So probably myself, I would ask a UK attorney to represent my clients there. But I hear that it's possible, in theory at least, that representatives that are currently representing EU trademarks will be able to communicate with the UK IPO in these cases, and might also be in hearings and these kinds of proceedings.
I think the important thing is that the UK has a great IP profession and a great IP industry. We work very closely with them and with our colleagues across Europe. And again, I come back to, we must remember, this is about how do we create the best environment for business. And help the region to be really innovative and creative, and ensure that works very smoothly. So, as I said, the withdrawal agreement and the data has been put forward to ensure that there is that minimum disruption as we go through this big change. Obviously, there are options for the future, but what we're keen to do is work with the UK professions, but also our partners and stakeholders across the region to ensure that we can create the right environment for businesses, both in the UK but also within the European region. As I said, the UK has made a decision to leave the EU, but we're still part of the European region, and will have very, very strong partnerships across all aspects of IP with our colleagues across the whole of the region. And that's hugely important to us. And we want to ensure that the UK is a fantastic place for IP, but that also the European region is a fantastic place for IP as well. And importantly, I think in this area that rights, there is the right environment to protect and enforce rights, both in the UK and across the region.
So we have talked quite a long time now about the UK and IP. I'm very grateful that I had the chance to interview you, especially around this time of the year. And I'm very grateful. Thank you for being on the show on IP Fridays.
Thank you very much indeed. It's been a pleasure.
That's it for this episode. If you liked what you heard, please show us your love by visiting ipfridays.com/love and tweet a link to this show. We would be so grateful if you would do that. It would help us out to get the word out. Also, please subscribe to our podcast at ipfridays.com or on iTunes or Stitcher.com. If you have a question or want to be featured in one of the upcoming episodes, please send us your feedback at ipfridays.com/feedback. Also, please leave us a review on iTunes. You can go to ipfridays.com/iTunes and it will take you right to the correct page on iTunes. If you want to get mentioned on this podcast or even have comments within the next episode, please leave us your voicemail at ipfridays.com/voicemail. You have been listening to an episode of IP Fridays. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by their respective law firms. None of the content should be considered legal advice. The IP Fridays podcast should not be construed as legal advice or legal opinion on any specific facts or circumstances. The contents of this podcast are intended for general informational purposes only, and you are urged to consult your own lawyer on any specific legal questions. As always, consult a lawyer or patent or trademark attorney. Copyright 2014, all rights reserved.